Plessy versus Ferguson was precedent, and Brown versus the Board of Education overruled it. So the Supreme Court has always said.
Sorry about the interruption there. Senator Tillis.
Senator.
Oh, your time's up.
Thank you.
Senator Blumenthal.
Thank you, Mr. Chairman. That was almost the shortest questioning session you ever had.
I was getting ready to defend you and say, oh, no, it's Senator Blumenthal's turn.
Hard to keep track of us. I entered some letters into the record, Mr. Chairman, I believe, before we broke.
Yes, sir, without objection.
And I began my questioning about the Third Circuit opinion in Binderup. I believe that you would agree that decision applied to misdemeanor offenses, correct? Not to felons.
Yes, I was thinking of the separate opinion that Judge Hardiman wrote, I think for 5, and it was a splintered decision, but the holding, I agree.
So it really doesn't support the dissent that you wrote in.
Judge Hardiman's position does for the 5, but you're right, I had misremembered the common judgment holding for the plurality.
Thank you. I want to ask you also, or clarify, the quote that I read to you was from a speech that you gave to the Hillsdale College, May 21, 2019, and it was, quote, about your opinion, dissenting opinion in Cantor, quote, it sounds kind of radical to say felons can have firearms, end quote. So I just want to clarify that was the source of the quote that I read to you.
Thank you. I, too, had looked at that because I was pretty sure I hadn't written the opinion. So I think, yes, it was in the course of explaining the opinion to that audience. I was saying it sounds kind of radical, but then going on to explain why it wasn't and the reasoning. But, yes, thank you for correcting that, Senator.
Thank you. I also want to go back to another aspect of our conversation because Senator Graham asked about it this morning. I showed you a letter that you signed from 2013 by the Notre Dame Faculty for Life, and specifically a sentence, the unborn to be protected. We renew our call for the unborn to be protected in law and welcomed in life. And then I asked you about the IVF procedure, whether it could be banned criminally under the Constitution. And you said to me that you couldn't answer that question in the abstract. You said, we can't answer questions in the abstract. I asked you about your legal opinion and position, not your personal beliefs or religious views. You understand that point?
Yes, yes.
And I am disappointed that evidently you can't tell us or the American people whether you believe or your legal position is that IVF can be constitutionally banned because so many Americans depend on this medical procedure for the ability to have children. I also want to ask you, should courts, specifically the Supreme Court, be deciding the next presidential election?
So the presidential election, as with all elections, is a matter put to the voters to cast ballots.
But the presumption should be against the courts deciding an election. It's the people and the voters who should decide, correct?
Let's see, Senator Blumenthal. So I think that occasions on which courts adjudicate election disputes are designed to protect the voter's choice and the right to vote. So, of course, the Supreme Court doesn't cast ballots. Voters cast ballots, and election law is designed to protect the right to vote.
The courts should do everything possible to avoid embroiling themselves in elective politics.
Russo versus Common Cause says that, for example, gerrymandering is a political question because it's difficult in many circumstances for courts to develop judicially manageable standards to...
Presumption should be against courts getting involved. Let me ask you about some precedents, and I'm asking not about super precedents.
Okay.
And as you define super precedents, they are cases so well settled that no political actions, no people seriously push for their overturning. I'm not asking you about what other people may think about these cases or may do about them, and I'm not asking you hypotheticals. These are real cases. First, Brown versus Board of Education. Do you think it was correctly decided? I know you told Senator Graham you thought so. I'd like you just to clarify that point.
Sure. So as I said to Senator Graham when he asked me that question, I have spoken on that before in the originalism lecture that I give students.
As you sit
said
here,
yes. And
correctly decided, right?
correctly decided, and yes, I've said that.
Thank you. Let me ask you about Loving versus the Loving case. Do you think that was correctly decided?
Well, Loving follows directly from Brown. Brown is correctly decided, Loving as well.
It was correctly decided.
It was correctly decided.
Thank you. Now let's talk about Griswold. Correctly decided?
Well, Senator Blumenthal, the reason
I know you
why-
gave an answer, excuse me for interrupting.
Yes.
I know you gave an answer to Senator Coons, but this issue is more than academic. That was the word that you used. You said that it's very, 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 very unlikely to be challenged, and maybe, but all the more reason that you should be willing to tell the American people it was correctly decided. I'm asking about your legal position. Would you have been in the majority?
Well, Senator, I have a couple of things on that. One is that the reason why I expressed a view on Brown to Senator Graham is that I do think what I have said in print, either in my scholarly work or in judicial opinions, is fair game. And I have expressly said in the past, in the originalism lecture that I've given repeatedly, that Brown was correctly decided. So I think that was fair game, and Loving is indistinguishable from Brown. It flows directly from it.
Loving involved interracial marriage, and Griswold involves a ban on contraception, criminal ban on the use of contraceptives, which in turn also involves Eisenstadt v. Baird. These are fundamental cases, and I'm asking your legal position. I want you to keep in mind how many people are listening and watching because they may take a message from what you say. They may see what you say and be deterred from using contraceptives, or may feel the fear that it could be banned.
Well, Senator Blumenthal, the position that I've taken is whether a question is easy or hard, that I can't offer an answer to it. And I would be surprised if people were afraid that birth control was about to be criminalized, because I said to Senator Coons,
You may
I don't
be
see any-
surprised, but Chief Justice Roberts said, quote, "I agree with the Griswold Court's conclusion that marital privacy extends to contraception. Justice Kennedy, if a hypothetical case were to be imagined that better fits within the privacy that I believe the Constitution protects, I couldn't think of a hypothetical better than Griswold." At his hearing, Justice Thomas said, "I believe the approach that Justice Harlan took in Poe v. Ullman and reaffirmed again in Griswold in determining the right to privacy was the appropriate way to go." And he reaffirmed Eisenstadt v. Baird. I'm stunned that you're not willing to say an unequivocal yes, it was correctly decided, I would have been in the majority. Lawrence v. Texas, which held that the government cannot criminalize gay and lesbian relationships. Was it correctly decided?
Senator Blumenthal, again, I've said throughout the hearing that I can't grade precedent, in the words of Justice Kagan, give it a thumbs up or a thumbs down.
So you can't give
and
me
it
a yes or no answer. Again, forgive me for interrupting, but my time is limited.
Well, Senator Blumenthal, I can't give a yes or a no, and my declining to give an answer doesn't suggest disagreement or agreement, and it certainly shouldn't suggest that
I'm asking your legal position, Judge, not your moral position, not a policy position, not a religious faith position, a legal position. correctly decided, Obergefell versus Hodges.
Senator Blumenthal, every time you ask me a question about whether a case was correctly decided or not, I cannot answer that question because I cannot suggest agreement or disagreement with precedents of the Supreme Court. All of those precedents bind me now as a Seventh Circuit judge, and were I to be confirmed, I would be responsible for applying the law of stare decisis to all of them.
But, Your Honor, think of how you would feel as a gay or lesbian American to hear that you can't answer whether the government can make it a crime for them to have that relationship, whether the government can enable people who are happily married to continue that relationship.
Senator,
think of how you would feel.
Well, Senator, you're implying that I'm poised to say that I want to cast a vote to overrule Obergefell, and I assure you I don't have any agenda, and I'm not even expressing a view in disagreement of Obergefell. You're pushing me to try to violate the judicial canons of ethics and to offer advisory opinions, and I won't do that.
Judge, you yourself wrote in 2016 an article that you co-wrote with John Nagel. It's called Congressional Originalism. Quote, a confirmation hearing answering hypothetical questions about the soundness of particular precedents is par for the course, end quote. It is par for the course because Americans want to know your legal positions on these issues, and they have a right to know. They deserve and need to know. And I am surprised, and I think a lot of Americans will be scared by the idea that people who want to simply marry or have a relationship with the person they love could find it criminalized, could find marriage equality cut back. I think it would be an America where I wouldn't want to live.
Well, Senator, to suggest that that's the kind of America I want to create isn't based in any facts in my record. And that quote that you read to me from the article talked about it being par for the course for those questions to be asked, but didn't say anything about whether it was appropriate for nominees to answer them.
Others have answered that same question, and I'm disappointed that you won't. Let me move on to another area. Last month, the New York Times published a series of bombshell reports dealing with the current state of the president's finances. There were a lot of revelations in that report, including that the president himself is responsible for loans totaling $421 million, most of which is coming due within 4 years. That amount of personal debt makes the president vulnerable to leverage, to manipulation, to coercion. His vulnerability makes him a threat to our national security. I'm not going to ask you about that aspect of his finances, or that he paid only $750 in income taxes in 2016 and 2017. I want to ask you about a fact that is critical constitutionally. During his first 2 years in office, the president received $73 million from foreign sources. Now, in the interest of full disclosure, I just want to say I led a lawsuit involving 200 of my colleagues challenging the president's receipt of those foreign benefits and foreign payments as a violation of the Emoluments Clause. And we cited as well other payments and benefits that he received from India, Afghanistan, Kuwait, Qatar, Malaysia, Saudi Arabia, Slovakia, and Thailand, and more, in violation of the Emoluments Clause. And we've been talking a lot about originalism. The Emoluments Clause was the premier anti-corruption clause in the United States Constitution. As Edmund Randolph of Virginia said, specifically, the clause was intended to, quote, prevent corruption, end quote, by, quote, prohibiting anyone in office from receiving or holding any emoluments from foreign states, end quote. The lawsuit that I led was denied certiorari yesterday by the United States Supreme Court. The D.C. Circuit Court of Appeals ruled against us on the limited technical issue of standing. It didn't deal with the merits. I hope that you will keep in mind the danger of corruption and the need to give citizens standing to enforce laws that prohibit corruption. Nobody is above the law. You've stated that position very well. And enforcement of laws that prevent corruption is vital. And my view is that the president, any president, must be held accountable. Do you agree?
No man is above the law. I agree with that, as I've stated very clearly before. And I also want to assure you, Senator Blumenthal, that I will apply all laws and come to an open mind with all laws, including laws dealing with anti-corruption.
Let me ask you about a topic that really hasn't arisen much here,
Okay?
climate change. One of my colleagues, Senator Kennedy, asked you about it late in the hearing yesterday, and your answer was, quote, "You know, I'm not a scientist. I have read things about climate change. I would not say I have firm views on it." Do you believe that human beings cause global warming?
Well, Senator Blumenthal, I don't think I am competent to opine on what causes global warming or not. So I
Well, we all have
really
views on it.
offer-
I'm
Yeah,
asking
but
for your opinion.
I don't think that my views on global warming or climate change are relevant to the job I would do as a judge, nor do I feel like I have views that are informed enough, and I haven't studied scientific data. I'm not really in a position to offer any kind of informed opinion on what I think causes.
I understand.
Global
And again, I apologize for interrupting. Do you agree with the president on his views of climate change?
I don't know that I have seen the president's expression of his views on climate change.
Okay. Let me ask you on another area. Are you aware of the Supreme Court, as it's called, shadow docket?
I am.
Essentially, this docket consists of cases that are decided, often stays or extension of orders, without an opinion, correct?
Correct.
And as a matter of fact, in the denial of certiorari in Blumenthal versus Trump yesterday, there was no opinion providing the reasons why they did so. We don't even know how many justices supported the decision, except that there must have been at least 5, and despite detailed reasoning from lower courts, which we challenge, about the issues, there was no opinion. And the same was true of the census decision, as you know. So don't you think there should be transparency on the part of the Supreme Court?
I think that the court, in the practice of denying cert petitions routinely, and you know, the shadow docket has become a hot topic in the last couple of years, but you know, even when I was clerking on the court in 1998, it was not typical for the court to issue opinions explaining why cert was denied, although sometimes there are dissents from the denial of certiorari which have opinions. But as far as I know, it's never been the routine practice of the court to have opinions.
My time is limited, but I just want to leave you with the very strong message, because increasingly the court has turned to this shadow docket. In fact, it's growing larger. It's up to 6,000 cases every year where it rules without an opinion and without disclosing who voted which way. That strikes me as anti-democratic with a small d. It decides only about 80 cases on its merits docket every year, which is smaller than when I was a law clerk on the court, and probably when you were a law clerk as well. So fewer cases, accountable, and less transparency. I am going to conclude here. I just want to say we tried to bring into this room real people who are going to be affected by your decisions. Some of them will lose their coverage. In fact, millions of Americans, including Connor Curran, will lose his coverage under the Affordable Care Act if he's denied the protection to people with pre-existing conditions. Legislative activism from the bench and the kind of activism that I fear you will bring to the bench is one of the against your nominee.
I understand, Senator.
Make it happen again. We're not paying the bills. Hello? Hello? Can you measure?
I don't think mine is.
This one's working.
It's not going to be
Hello? Hello? Hello?
So it's not connected to you.
I apologize. Many business in Blumenthal. We got your time in.
Thank you. I'll just finish on this note. I'm also deeply disappointed that you're unable or unwilling to state your legal position on whether certain cases have been correctly decided. You know, there have been a lot of references to the Ginsburg rule. I think this administration has taken the Ginsburg rule to a new level. I hope it won't be known as the Barrett of avoiding responses like that. But I think that other nominees or lower courts have adopted the same stance, and I urge the administration to encourage its nominees to be more forthright to us, because the American people and all of us have a right to those that knowledge about the legal positions. I thank you.
Senator Silvers.
Thank you, Mr. Chairman, and thank you again, Judge Barrett, for your indulgence. Before I get started, I just want to assure Senator Cornyn and Senator Cruz that I will not cast aspersions on human Astros, because I believe Senator Sass, who I laid out in our implied case. Judge Barrett, I've got a quick question for you. I've got 4 cases, U.S. versus Lopez, D.C. versus Heller, Hobby Lobby versus Burwell, Washington versus Blackburn. Microphone's not working.
Take a 5 or 10 minute break and see if we can get this.
I did not cast aspersions. All right.